to try to find out why I was swatted in LA. They had snipers on the roof, and they were green lighted to take me out and shoot and kill me.
All rise. The Second Judicial District Court of the State of Nevada is now in session. The Honorable Barry Breslow presiding.
Thank you, Deputy. Good morning, everyone. Please be seated. All right, we're on the record in the case of State of Nevada versus Mr. Hillygus and Mr. Handte. I'm here with counsel for the state, Mr. Stege. I'm here with counsel for Mr. Handte, Mr. Silverberg, standby counsel for Mr. Hillygus, Mr. Goodnight, and the defendants are here as well. This was a date set for the continued change of plea hearing. As I mentioned at the last hearing, I was hoping that if we were going to move forward this morning, signed either guilty plea memorandum or no contest plea memorandum would be filed. That doesn't appear to have happened. And I've been advised as well, it's not likely that the court will be having a change of plea canvass this morning. Based on that, unless somebody says, Judge, you have it wrong, we actually are going to do that. The court is going to reset this trial for 2 weeks, indicate that there will be no more change of plea hearings set between now and time of trial unless and until signed GPMs or no contest plea memorandums are filed, and we will get ready for a trial. Now, to find 2 weeks in the midst of all the other matters the court is handling, it's been a challenge, but the court has come up with 2 weeks, which I'll give you in a moment. And then we're going to talk about Mr. Goodnight's role, or really lack of role, from this point going forward. But first, let's talk about dates. Mr. Gaynor, what does the court have available, please?
Our first trial was available January 22nd.
All right, do we have 2 full weeks available?
Yes.
All right. Mr. Stege, does that work for the state?
Thank you, yes.
Mr. Silverberg?
It does, Your Honor, thank you.
All right. Either Mr. Goodnight or Mr. Hillygus, any reason those dates won't work?
I don't agree to that date because I invoked my right to a speedy trial, which I've done 4 or 5 times on the record in writing. And there's been 20 continuances over my objections to a continuance. So I'm prepared to make a record today regarding my 6th Amendment right to a speedy trial, and that this case should be dismissed. Or this is going on 50 months now, 5 years. I've been detained for a year, and at this point in time, I'd like to take notice and demand to dismiss this case under my 6th Amendment right to a speedy trial, which has been denied under Doggett, D-O-G-G-E-T-T versus United States, 505 U.S. 647 Supreme Court, and Barker, that's B-A-R-K-E-R versus Wingo, W-I-N-G-O, 407 U.S. 514-530 United States Supreme Court. The Barker criteria, there's 3 requirements for a Barker criteria for this court to dismiss this case for a lack of prosecution. One is a presumptive prejudice for the delay, and it's been egregious, it's been deliberate with intent, and it's bad faith and negligence. It's failure to prosecute. Negligence must be particularized to prejudice suffered, the length of the delay, the reason for the delay, and this was wholly unjustified and unreasonable because I've objected and I've filed documents on the court objecting to the continuances. The extent that I've asserted my right to a speedy trial, I've done that 4 times in writing to the court, and I've done it today, right now. There's 4 separate inquiries. This has been uncommonly long delay before a trial, 50 months, we're in the 5th year. The state and the DA are to blame for the delay. The state has a duty to the public. Whether the defendant asserts his right to a speedy trial, which I have, I've addressed that, and whether the defendant suffered a prejudice as a result of the delay, and I have, and I will outline that, the prejudice that I've experienced. Let me talk about the length of the delay. The Supreme Court has said in Barker that 5 years was extraordinarily long. Likewise, in Ringstaff, R-I-N-G-S-T-A-F-F versus Howard, 885, 542, 11th Circuit, 1989. It was presumptively prejudicial for a 23-month delay. United States versus Baga, B-A-G-G-A, 11th Circuit, 1986. 36 months delay was prejudicial, presumptively prejudicial to the defendant. And in U.S. versus Mitchell, 769, 1544, 11th Circuit, 1985, 29-month delay is presumptively prejudicial. And the U.S. versus Denard, D-E-N-N-A-R-D, 722, 1510, 11th Circuit, 1984. 15-month delay resulted in a dismissal as a Barker element to dismiss for deliberate intent and bad faith in this case. The reason for the delay equates to bad faith by the state and the district attorney. It's prosecutorial misconduct, it's a malicious prosecution, and it's a violation of the unclean hands doctrine, which has been cited in my notice and demand to dismiss for unclean hands, which has not been responded to properly by the state. Administrative policy or orders are not law, and the public has seen continuance after continuance after continuance. Like I said, there have been 20 continuances in this case, and I moved to Texas lawfully, and I had a right to travel, and there's still been no finding of fact or conclusion of law for my jurisdictional challenges, which I had filed 3 times over that time that I've moved to Texas. There is no victim in this case. There is no certificate or writ of probable cause signed by a judge in this case. The state and the district attorney have unreasonably prejudiced me in this case. Steve Evenson was threatened with physical violence by the Reno Police Department for me contacting the FBI to try to find out why I was swatted in LA. They had snipers on the roof, and they were green-lighted to take me out and shoot and kill me. And I had not committed a crime, or I was not fleeing the state. There was nothing that I was fleeing from.
I need you to stay on the point, your legal point you're making as to why the court should dismiss the case because of the failure to bring you to trial timely.
David Houston was also threatened in this case by the RPD, and I've got a voice recorded message stating such. The reason for the delay is the state is gaining an advantage, and I've been unduly oppressed and incarcerated prior to trial, which is a due process violation. I've been hospitalized for a heart condition. I'm on special medications for my declining health. I've had 2 injuries while I've been incarcerated in the Washoe County Detention Facility. They left me in the sun with heat exhaustion. I know I've talked about that. And I had a fall injury as a result of a threat by the Washoe County Sheriff's Office Sergeant Gaston. I'm experiencing stress and anxiety and weight loss while unlawfully detained. I'm confronted with 24 to 72 hour lockdowns, which is harsh punishment and it's punitive. It's a treat. And there's no due process for me to access the court. I'm being denied access to a court as a due process violation, and I've had no table or chair in my cell where I'm being kept for 23 hours a day often. These are constitutional violations of my 6th Amendment and 5th Amendment right to due process and to a speedy trial. There's been no bail hold. I'm on a no bail hold, and there's been no Johnson hearing. This is a violation of List versus Nevada. It's a due process violation of my right to have this case drug on for going on 5 years. I have lost my wife, I've lost my marriage, I've lost my extended family and friends, and I've lost my support in this community. I faced public accusations for false media reports and defamation of my character, which was outstanding prior to this criminal case going on 5 years. The due process violations involve a prejudice to the accused's ability to defend himself. There's been the death of Bob Wilson, who is a prime witness that was my mother's best friend that she wanted to visit down in LA, along with his son and daughter Lisa and Rob. There's been the death of John Casagrandes and his wife Karen Casagrandes, which were also friends of my mother from the neighborhood she grew up in down in Southern California. The memory is failing of my mom's brother, my uncle. His name is Roger Robbins. He's in his 90s now and he lacks capacity. He would be a prime witness for the defense. And his common law wife, Wilma Dester, is also suffering from cognitive decline. And my cousin, John Robbins, has health issues and he's disabled. And he would be a witness as well. So this delay is causing prejudice to my ability to defend myself because I'm being incarcerated and witnesses are not able to testify on my behalf. The exculpatory evidence is incredibly large in this case. I filed what's called
Let's keep on the track of why the delay is prejudicing you.
because it's a Brady disclosure violation by the state. I've filed what's called a statement to the grand jury, and I've listed all the exculpatory evidence which is being withheld, and I've placed it on the record here as well. There's a massive amount of exculpatory evidence which is being withheld that will prove my innocence in this case.
All right, I'm going to need you to wrap it up now.
I'm going to wrap it up.
Thank you.
There's judicial misconduct and prosecutorial misconduct. First of all, there's been ex parte communication with this.
Well, hold on. I need you to, right now, this isn't the time or place to air those grievances. This is the time and place where I've asked you if this date will work for you. You've said no, and you haven't proposed a different date. What you're saying is, Judge, I object to any date, and primarily because the delay has been unreasonably long and prejudiced you, right?
This court is obligated under the law, under the Sixth Amendment, my right to a speedy trial, which has been denied for 4 years now. And I've got all of the reasons that I've expressed in all the case law.
You've expressed quite a few.
And there's also judicial misconduct in this case, ex parte communications, threats by the judge for me not standing up or speaking my First Amendment right, directing or ordering the court
So
reporter
Mr.
to change a
Hillygus,
transcript.
I need you to stay keep this train on the track here. And the track is there anything else you want the court to know as to your objection to the proposed trial date in January? And I'm going to hear from Mr. Stege in response. As opposed to the objections to this court's jurisdiction, to the fact that it should have been bound over, to the way you were treated in Texas, the way you were treated in, or not Texas, the way you were treated when they brought you back here on the warrant, the way you were treated in Southern California. Is there any particular reason why January date should not be used as opposed to some other date? Understanding that you feel strongly that this case should be dismissed for a variety of reasons.
It's a violation of my Sixth Amendment right to a speedy trial. I filed on February 11th of 2020 my right to a speedy trial. I filed on February 18th of 2020 my right to file for my right for a speedy trial request. On May 18th of 2020, that was also placed in writing. On June 29th of 2020, and I've objected on 6/29 and on 5/18 and on 7/22 of 2020, objected to the state moving forward with a continuance and a continuance and a continuance. There was 13 just in the Reno Justice Court, and there's been at least 6 in this court.
All right, let's stop right there. I understand your position. So, Mr. Stege, I'm offering you an opportunity to respond to some of the concerns on the delay. The court would note, though, that factually some of the requests that Mr. Hillygus indicated occurred right smack in the beginning of the pandemic where there were no trials happening. And that was a good year to maybe 15 months before we found our way and started doing trials again. That accounts for part of it. And the Supreme Court of Nevada has issued, as I recall, decisions that have stated that based on the public emergency, public health emergency, that those are not reasons that normally would be a factor for determining somebody's constitutional or statutory rights to speedy trial. The other issue is Mr. Hillygus was outside the jurisdiction of this state on warrant status for over 6 months, maybe even closer to 9 months. That added quite a bit. And then when we were set to go to trial a month ago, I canvassed everyone and I said, should we hold the trial date pending these negotiations? And the collective response was no. And so the court is, then we were supposed to be here, we were here 2 weeks ago to put things on the record, and that didn't happen. And they gave everyone another 2 weeks, and that didn't happen. So if anyone's frustrated, the court is equally frustrated that the people of Washoe County are paying for Mr. Hillygus to remain incarcerated pending the resolution of this case. And I've already told Mr. Hillygus that if he comes up with a plausible plan, where he's going to live, how he's going to be supervised, he understands he'll be subject to GPS monitoring and modest bail, we can change his custody status. easy for the court to say, I understand, harder to put in place based on the current circumstances. But the court never forecloses taking another look at custody status during the pendency of a case, particularly one that has been pending for this amount of time. But those are 2 or 3 thoughts that accounts for at least 2 years, maybe 2.5 years of this delay right there, putting aside some of the other issues, challenges, and motion work. Mr. Stege, though, any thoughts on this, and then we're gonna have to conclude discussion.
I would add to that, the September 21st of 21, that was his arraignment. It postdates the demands or what he's, the defendant is saying.
So the clock doesn't even start till then, right?
So then he waived Speedy at that time. He also filed a writ which requires you to waive your Speedy. Now that is statutory.
Well, and once it's waived, you don't really put that genie back in the box, right?
Right.
It's not waivable for a while and then invoked later. So.
Right, and then, shortly into our judicial time, February 9th of 2022 is when this court issued the warrant. It was quite some time until we did see.
All right, well, I mentioned that, so.
Thank you.
All right, so let me
I would
just,
object to the writ. That was based on a contingency that Steve Evenson was going to file the writ. He did not file the writ, so there was a contingent on him doing that,
Okay.
and he did not do that.
okay.
I did not know about the warrant. I lived my life normally. I traveled the country. I moved. I filed documents, and they were not responded to. So I object to that as well.
Okay, I understand. So here's how we leave this hearing. We have our trial, it's going to be in January. We're not going to pick a date right now, but when we get closer to the January trial date, we will pick a date to meet the week before, and I will give everyone the redacted jury veneers as the court was prepared to do a month ago. Redacted pursuant to the court's order deeming the jury panel to be anonymous in this trial. So the state and the defense will get the veneer information at the same time here in open court. Number one. Number two, Mr. Goodnight, I'm going to have you stay on as standby counsel for the purpose of settlement resolution matters, if any, only between now and the date of the trial. Because I don't want to foreclose that parties can keep talking. I don't want to foreclose that there might occur a change of thinking. I don't want to foreclose that there may be a path forward on resolution if the parties are so inspired. That would end up with an actual change of plea. Didn't go forward today, didn't go forward 2 weeks ago, may never go forward. But in the event that parties keep talking, Mr. Goodnight, the court wants you to remain as a resource to Mr. Hillygus through that process. Obviously, if we get to the trial, you'll be thanked and excused at that moment and have no further role. Again, do not set another hearing for a change of plea absent signed memoranda that explains what the terms of any resolution are. Mr. Goodnight.
Your Honor, I think that's fine with those limitations that the court said for settlement purposes only. I'm not trial counsel.
True.
I'm not investigating trial defenses. I'm not doing clerical work or administrative work. I'm not issuing subpoenas. That is all on Mr. Hillygus. That
Agreed.
avoids the potential conflict that comes up with standby counsel when you have a defendant who's representing themselves that wants to pursue defenses or defense avenues that may put the standby counsel in an ethical quandary or pickle. And so, as long as everyone's clear that there are boundaries to my affiliation with Mr. Hillygus and his case and my role as standby counsel for settlement purposes only, I'm okay with that.
Okay, very good. So, Mr. Hillygus, you may never have Mr. Goodnight work with you again on this case. It's only if discussions continue. It's only if you want to run things by him. It's only if you wanted to take a look at documents that have been forwarded to you for your review and consideration. It's only if you want to use him to communicate a response to an offer, if any, or your own, whatever it is. And it may be never. Maybe never. Nothing happens, and we pick our jury and the trial goes forward. But he's there in case you need him.
I hear what you're saying, and I want to make a statement regarding what we were just talking about. I requested my public defender to assist me in preparing a notice or a request for submission of my notice and demand to dismiss this case for lack of standing.
Hold on,
I also-
hold on. I don't need to hear this right now. I just want you to.
This is
This is only with respect to settlement, and you shouldn't be putting on the record now anything regarding discussions, negotiations. That's private. That's between you and your counsel, or your standby counsel, or you and Mr. Stege. You don't have to say anything about this because I don't want it to work to your disadvantage. I don't want anyone to use it strategically. I don't want anyone who watches any media reports of this hearing to know what the issues were. That's your business.
I do have to.
Wait, hold on. You, Mr. Goodnight.
I think it is worth clarifying. As Mr. Hillygus is representing himself, he's the one that needs to file responses. He's the one that needs to file, if he's going to join Mr. Hante's motion to dismiss, he needs to file that.
That's his job, not yours.
I will make an oral notice and demand to make a joinder. I make a notice right now to the court that I file a joinder to join
What was recently filed by
the
the,
alternative public defender's motion to dismiss for prosecutorial misconduct. And I do want to get this on the record that Mr. Goodnight is now aware of falsifying
Stop,
evidence,
Mr.
NRS 199.
Mr. Hillygus, please stop.
As an officer of the court, he is obligated to inform the court that he is aware of now criminal acts, in this case involving the district attorney and the Reno police, involving falsifying evidence, misconduct of a public officer, NRS 197, a false report of a public officer, 197, a public officer
So
making
wait,
a
hold on,
false
Mr.
certificate.
Hillygus, when I ask you to stop speaking, I need you to stop speaking.
Well,
And, you know, I
need
give you high marks on your grit and your tenacity, but let's just leave it at this. Mr. Silverberg, on behalf of Mr. Handte, recently filed a motion based on their view of action or inaction taken by the district attorney. The district attorney's office, I presume, will respond to that motion. Now, if you're saying, Judge, please take notice that I join in that.
I join in now.
Okay, noted. In addition, if you want to file something that expresses your view, or, as I would encourage you, to more formally join in, please do so, and I'll consider it. But I'm aware, because you said it on the record, that you join in the arguments made by Mr. Handte. Mr. Stege, any comments on that issue? Then we're going to end this hearing.
I understand why the court's doing that. I would just discourage that in the future. So
Well, I'm not usually going to let, the oral statements, but we're all here, and he wants to make sure this doesn't get, for some reason, his position not made known, and the court takes note of it. The state's going to respond, there will be a reply, it will be submitted, the court will make a decision. All right?
Thank you.
So one more time, I'll see everybody in January, at least the Wednesday or so before the trial. Veneers will be put out. If you continue to talk in an attempt to resolve these matters, I'm available to set a hearing for a change of plea, but we will not be setting a hearing. Don't ask my court clerk to set a hearing. We're not getting people involved in court hearings that are going to end up with us just moving forward without a resolution. And I'm not arm twisting anybody to resolve this in any particular way. That's not my business. My business is to make sure both sides get a fair trial. But if it's going to be resolved, I need signed documents filed before the hearing, so I know we're serious and we're going for it. Absent that, I wish everyone a pleasant afternoon. Thank you for being here. Court's in recess.
Thank you, Your Honor.
All rise.